Talk a little bit about the Fourth Amendment schools, and how we're going to do this is we're going to do an activity with this video, and you're going to follow along on your Google Doc and fill it in. You might have to pause at times to fill some things out, and I'll kind of give you some notification or kind of heads up when to pause. But we're going to talk about your rights, Fourth Amendment search and seizure when you are in school. So if you follow along, first thing, we're talking about like things in class. I know we're not in class right now, but the things that you would have in class. So what does the Fourth Amendment really mean to you? Imagine you were in class. What does it mean to you right now? If you were to sit in class, if you were in my classroom, you have different things that you would carry on you. Those are called your effects. And you bring your personal belongings. You bring backpacks and cell phones and purses and jackets and things like that. That is your stuff. So what right do you have to keep your stuff private while at school? Think about that. Does it change then if you're not at school? Or if you are at school, does it change if you're at home? Does it change when you're in a courtroom on an airplane? Does it change depending on what it is that you're carrying? So are different things uh, more private to you? And that's kind of the challenge. That's the challenge behind the Fourth Amendment. So what I want you to do, take a minute here and make a list of your items that you would currently have in class right now. At least 5, no more than 10. So if you need to pause the video quick, do that. Write down that list in the box on your Google Doc. All right, now that you have your list, these are the effects. These are your things. Maybe they're papers. We know you are in school. The question is, does the Constitution protect these things? Does it protect these effects from an unreasonable search or seizure? Do they need probable cause is kind of the question we're asking. So the answer depends on whether you have a reasonable expectation of privacy, and we've talked about this in those different items. In most Fourth Amendment cases, the question will be whether that reasonable expectation was violated by an unreasonable search or action of government. So here's our first exercise. What is a reasonable expectation of privacy? And we're going to look at 2 parts. First, do you actually expect privacy in your effects that you bring with you to school? Yes or no? Highlight yes or no. Now, go through the list that you wrote of your effects above. Do you expect those things to remain private? Overall, answer in the box provided. Now, the second portion of this is this expectation of privacy one that others agree? So, would you disagree with someone? Go through the list of effects again that you wrote down. You can write them again right here. You would ask. So, if you could ask someone, maybe ask someone in your house or a friend, if you think that everyone would agree that certain things deserve more privacy than others. Maybe it's a personal medicine, phones, things like that. So write down your item. Should these items remain private, yes or no, and why? Pause the video if you need some time to fill that out. All right, moving on to the next exercise here. Take one of those effects. Maybe it was a notebook, for example. Imagine that a police officer actually comes into the room and wants to read that notebook. So think about this. Could be a different effect, but we'll use the example of a notebook. Do you, the student who owns that notebook, expect that what you wrote will remain private? Yes or no? Highlight one of those. The second question, do you think that what is written is reasonable to keep private? Why? Yes or no? And tell me why. Is it reasonable? That's what you're really answering. Is it reasonable to remain private? If the police do not have any real reason to suspect you, should you have a reasonable expectation of privacy? So if you feel you did nothing wrong, should you have an expectation of privacy? Yes or no? Highlight one. Now let's look into your conversation. So are conversations any different? So instead of a thing like a notebook, a backpack, or a book, what expectation of privacy do you have in what you say to people? Should you have an expectation that what you say remains private? Yes or no? Highlight one. Which of the following then seems like a situation that would give you the most privacy? So let's rate. 1 being the most amount of privacy, 5 being the least amount of privacy. Take your time here. You can use different number more than once. So you have a conversation between two people loudly yelling in a packed school auditorium. You have a conversation between two people speaking in a normal tone alone in the bathroom. A conversation between two people whispering on stage in a school auditorium. A conversation between two people whispering in class. And a conversation between two people in the middle of a football field when there's no one around. So 1 through 5. Pause the video if you need to. So why do you think your answers are different between those? Is it where you were at when you were talking? Is it how loud you were talking? Who you were talking with? But what controls your expectation? Answer below. Now, a different example. Think about the conversations you have on the phone. Do you have a reasonable expectation of privacy there? Do you feel what you say on the phone should remain private? Answer below. So the Supreme Court has really discussed and addressed the idea of expectation of privacy. We talked about the cats in the United States case already in this course. So here's a refresher. You're going to watch a little bit of video on cats versus United States and the concept of an expectation of privacy.
The Fourth Amendment to the United States Constitution guarantees that people will be safe from unreasonable searches and seizures. In the Supreme Court case Katz versus United States, the court developed the idea of a reasonable expectation of privacy. The Katz case dealt with wiretap on a public phone booth in an attempt to catch a gambling ring. The court stated that there was an expectation of privacy in a phone conversation, even if that conversation took place in a public phone booth. The court also ruled, though, that anything that a person knowingly exposes to the public, regardless of location, is not protected by the Fourth Amendment. A person must keep something private for the Fourth Amendment to apply. To determine whether there exists a reasonable expectation of privacy, a two-pronged test has been established. First, the person must show a subjective expectation that his activities or items would be private. Second, the individual must show that his subjective expectation of privacy is one which society considers reasonable. To illustrate how this test works, let's consider cases in which there are and are not reasonable expectations of privacy. People have reasonable expectations of privacy in their own persons, homes, vehicles, and business offices. They also have reasonable expectations of privacy in their personal communications, such as telephone calls, letters, and journals. Moreover, if a person needs a key or password to gain entry into a space, whether they are physical or electronic, there is also an expectation of privacy in that space. Examples here include cell phones, computers, bank safety deposit boxes, lockers, and luggage. In contrast, people have no reasonable expectation of privacy in public spaces, where their actions, content, and possessions can be seen or conversations heard. Again, whether the content at issue is physical or virtual. Examples of such places are public sidewalks, venues hosting sporting events, and public parks. There is no reasonable expectation of privacy in discarded garbage left in the street. Electronically, there is also no reasonable expectation of privacy in the GPS location of a vehicle, electronic bank records, communications via the internet, including as email, chat room, or social media, in files accessible through file sharing software, in information provided by customers to internet providers, including identifying address information, or in phone numbers dialed. A person also has no reasonable expectation of privacy in odors emanating from one's person or luggage. This is why, for example, a police officer who smells alcohol on a driver's breath may use that fact as evidence against the driver. In fact, a 2005 United States Supreme Court decision ruled that police dogs trained to sniff narcotics that indicate the presence of narcotics in a car could provide the probable cause necessary to allow police to search the vehicle. Furthermore, a passenger in a car has no reasonable expectation of privacy in the contents of that car. So, for example, if a vehicle's driver consents to the search of a car, materials found in the car that belong to a passenger can be used against that passenger. The driver, on the other hand, does have a reasonable expectation of privacy in the contents of the vehicle, and thus can refuse police permission to search the vehicle, unless the police otherwise have a legal right to search it. By the same token, while a homeowner or renter has a reasonable expectation of privacy in the contents of the home, a guest in the house has no reasonable expectation of privacy in that house. If the homeowner consents to allow police to search a house, the possessions of the guests in that house are fair game. Even in places and in items where there is generally a reasonable expectation of privacy, exceptions exist. For example, even within one's home or property, the open field doctrine provides that if something on a person's property is easily visible to the public without the need to be physically on the property, for example, from the air or from the street, then there is no expectation of privacy. For example, the police can use photos taken by police helicopters above one's property of items that are visible from the air. The expectation of privacy is reduced for people who are public employees. Employees who hold safety or security-sensitive jobs, such as bus drivers, train conductors, law enforcement officers, or laboratory workers, for example, have reduced expectations of privacy. Because of the trust society is putting in these individuals, that compelling state interest overrides the individual's expectation of privacy. These people may, for example, be subjected to drug testing that the government would not subject an ordinary person to. Moreover, when people voluntarily enter spaces in which the government has an elevated security interest, the expectation of privacy is likewise reduced. The most obvious example occurs at airports. Transportation Security Administration agents may subject airline passengers and their luggage to virtually unlimited searching with virtually no cause, which would never be allowed in most other contexts. Rules relating to the doctrine of expectation of privacy do not operate within a vacuum. Reasonable expectations of reasonable people, factors including location, nature of the objects or data, and many other factors must be considered. As such, whether a reasonable expectation of privacy exists is a matter that is determined on a case-by-case basis and is fact-specific.
Let's start part 2 here of expectations that you have at school when it comes to search and seizure, Fourth Amendment, so your expectation of privacy. So what about public school? We talked about your effects in school, but what about public school? What expectation of privacy do you have when you come to a public school? Again, schools are in place to teach, to have you guys learn. They're also a place of living where students bring all your different personalities and problems. Think about how long you guys are at school each and every day. And they want people to bring their individual personalities uh, so that they help others learn. So let's go to the question, back to the question of your effects and what you have in class. We know that it cannot be the case that you should be able to bring anything to school. All schools have rules designed to protect the people that are there, the students, the teachers, the workers, and to create a positive learning environment. So bringing a gun or knife, obviously, is not allowed and is illegal. But at the same time, even in dangerous times, we do not want all of your personal freedoms to be taken away. Just because you walk into school shouldn't be taken. All your personal freedoms should be not be taken away. So we value those things. We don't want the government to intrude on everything. We want people to bring parts of their normal personalities and creative lives to their school. So how can a public school actually enforce its rules without taking away your rights? So this is the idea behind school searches. What are the rules governing official school searches of students and their belongings for things like drugs, weapons, and other harmful things? On one hand, so some people defend student rights, who are defending your rights, think that school authorities should be forced to actually go to court, have a probable cause, which is a high level, and then get a search warrant from a judge before actually searching anyone or anything at that school. On the other hand, though, some people who like this doctrine, its Latin term is in loco parentis, so meaning the place of the parent, say schools should simply have the right to search students and property however they want and whenever they want, because they're acting as the parents, they say. But the Supreme Court really has kind of refused to take one side or the other. Okay, so in one case, students have all the rights at school as they have elsewhere, and in the other, they essentially have no rights when they come to school. There's a case that we will discuss in the next part is the New Jersey versus Tiello. So the court, under this case, found that school authorities need not obtain search warrants. They don't have to get search warrants or even have a probable cause to search students at school. But they cannot simply just search them whenever they want. So in carrying out searches and discipline, school officials act as representatives of the state because they work for the state. So our assistant principals and deans and even our SRO, they act as a state official, but not merely as surrogates of the parents. Where your parents, they can search your room whenever they want. When it comes to the bodies and personal belongings of students, schools can search without a warrant as long as they have a reasonable suspicion. So that's a big term in this course. A reasonable suspicion to think that the students are breaking the law or the laws of the school community. Again, it can be violating the law or even a school rule. The bottom line is that students have some Fourth Amendment rights still, so protection against unreasonable searches and seizures, but not many. In theory, this particular balance struck by the court increases security for students and teachers while reducing student liberty and privacy. So after understanding all this, is this a good trade-off? Answer below. Take some time here and answer below. Is this a good trade-off? Okay, the next thing to think about, are schools secure? Do students feel free or restricted at school? How much educational time is consumed by security investigations, metal detectors, locker searches, drug testing, dog sniffs, all those things? So would it be reasonable to always have searches, not have searches at all? So things to look at, things to think about. On a scale to 1 to 10, 1 being the lowest and 10 being the highest, define your expectation of privacy in the following areas. The privacy you believe you have against inspection and surveillance by school authorities in the following areas and items. Numbers can be used more than once. So again, 1 being the lowest expectation of privacy, 10 being the highest. And here's the list. Your school locker in the main hallway, a gym locker in the boys or girls locker room, the backpack that you have, a bathroom stall with the door closed, just being in the hallway, a purse or a wallet in your locker, the desk in a classroom. So almost imagine like a elementary classroom where you have some stuff in a classroom. Clothing, including pockets and underwear, that you are actually wearing or clothing that you're not wearing. So again, on a scale of 1 to 10, with 1 being the lowest expectation of privacy and 10 being the highest, rate those, and numbers can be used more than once. Take some time to do that. Now again, your search of your belongings. Because the privacy interests of school children are outweighed by the substantial need of teachers and administrators to maintain order in the schools. Again, the reason behind school is to learn. So you have to maintain that order, follow school rules, make sure people are safe and comfortable and go smooth. The Supreme Court has dropped the requirement of probable cause. Probable cause is a high possibility that you've done something wrong. So the Supreme Court has dropped that requirement, and they don't require a search warrant when schools are investigating violations of schools and criminal laws. What schools need is a reasonable suspicion, a tip of some sort. Uh, Maybe someone said, this person's doing that. I think they did this. I think they said that. They might have this on them. That could be reasonable suspicion enough. If they constantly hear the same name, that's reasonable suspicion. They don't need probable cause or a search warrant. Part of Fourth Amendment in schools. Uh, this is the court case that has defined the expectation of privacy, reasonable suspicion. So New Jersey versus TLO. The state, obviously, and TLO are the initials of the juvenile because you cannot use a juvenile's name in the court system. You can only use their initials. So again, it established a lower standard for official searches in public schools by school authorities, reasonable suspicion. And this is one of my favorite cases. So TLO, the case summary. So the question for the Supreme Court was whether public school officials, like a principal or assistant principal, needed that probable cause or a warrant to search a student's purse when he believed she was smoking. So they believed she was smoking cigarettes in school. Did they have to have probable cause or a search warrant, or could they just kind of get it on a tip? So the facts behind the case. There's a 14-year-old girl, the initials of TLO, was suspected of smoking cigarettes in the bathroom with another student. Both girls were brought to the principal's office. TLO first denied smoking. The other girl confessed. The principal decided to search TLO's purse. He did not. He did so and found a pack of cigarettes. After finding the cigarettes, he continued to search and found marijuana and other items associated with marijuana selling. During her juvenile prosecution, TLO challenged the principal's search as a violation of her Fourth Amendment rights. Remember, the Fourth Amendment protects against unreasonable searches and seizures. So, what was the outcome, the holding of the court? The court said this. The court held that the Fourth Amendment applies to high school students in public schools, and that students retained a limited reasonable expectation of privacy. So you do have privacy. However, the court upheld the constitutionality of the search, so they allowed it, reasoning that the principal has reasonable suspicion to search the purse for a violation of school rules. Again, she was also breaking school rules, and we're talking about a learning environment. So the initial search was reasonable because the principal suspected TLO of violating school rules and smoking. Then again, the principal continued searching, so the second continued search of the purse was reasonable because cigarettes and other suspicious items had been found. Thus, there was no violation of the Fourth Amendment. So because she violated something, she broke something, and that search was okay, they can continue to search. So what is the legal issue behind this? Well, the first legal issue was whether the Fourth Amendment was even applied or even should address high school students. The state of New Jersey had argued that because of the extensive regulations that students have to follow in schools, students did not retain any reasonable expectation of privacy. The Supreme Court rejected this argument, holding that students did retain a reasonable expectation of privacy in the things they brought to school. So you do have some privacy. Another legal issue was whether that probable cause or search warrant requirement, should they have to have those, should be applied to you at a school setting. The court held that a lesser standard made more sense in the context of a school. The court adopted the reasonable suspicion standard, holding that the search is reasonable considering all of the circumstances. The court offered a two-part test. So this is the test they used to see if it is worthy or it was constitutional. Number one, whether the search was justified at its inception. And number two, whether the search was reasonably related in scope to the justification. In this case, in the TLO case, The initial search was justified by the suspicion of smoking. You can search because you're violating rules. They suspected the smoking, so you can search. The second search, so the continued search, was justified because other suspicious items were found with the cigarettes. So in the cigarettes, they found something, they continued to search. So let's discuss this case. Let's talk about things here. Things to think about. Do you agree with the majority in this case that schools could not be functional institutions, so we couldn't function as a school, if administrators needed to go to court every time to get a search warrant before searching belongings? Why or why not? Take some time here and answer below. Okay, the next thing to ponder is schools do not have to seek warrants to search students. Should the schools then be able to turn over evidence of crime they find, like drugs and weapons and guns, to state prosecutors, so to the police? Right now, they can do that, and the students can be prosecuted. Does that make sense? So if they're breaking the law in school and they don't have to get or have probable cause or a search warrant, should they be able to turn those things over to law enforcement? Answer below. So kind of just reviewing it here. The court, again, and TLO applied a two-part test to determine the reasonableness of any search. So one, whether the search was justified when it began, and two, whether the search that took place was reasonably related in scope to its original purpose. A search of a student ordinarily would be justified when reasonable grounds exist for suspecting that it would produce evidence that the student has violated or is violating either the law or the rules of the school. Again, it could be the law or school rules. Such a search would be reasonable in its scope when the measures adopted are reasonably related to the purpose of the search and are not excessively intrusive in light of the age and gender of the student and the nature of the infraction. So, consider the following hypothetical situations. What I want you to do is to follow along when I read this and then answer below why or why not. Were the rights violated? Should this search be allowed? So, the first one, Jenny Jefferson borrows a CD from her friend Carmela Costas, promising to return it after she's had a chance to burn it. After 2 weeks pass, Carmela gets impatient and asks Jenny about the CD. Jenny promises to return it soon, but Carmela is so upset she loudly complains about it in class. Mr. Williams, the classroom teacher, gets tired of hearing about it and asks Jenny to open her bag so that he can look for the CD and give it back to Carmela. Before Carmela can respond, Mr. Williams grabs the bag, opens it, and while he's fishing around, finds not only the CD but also finds a small bag of marijuana. He refers it to the police officer at the school, and drug charges are brought against her. Using your understanding of TLO, do you think the teacher, Mr. Williams, violated Jenny's Fourth Amendment rights by searching her bag? Yes or no? And provide me evidence behind your answer. So why or why not? Answer in the box below. All right, scenario number 2. We have Johnny Walkman, an Eagle Scout. He brings to school in his backpack a pocket knife that he had with him on a camping trip, so he used the same bag. Walking through the metal detector at the front door of his school, the pocket knife sets off the alarm. Johnny says, "Oh no, I forgot about my pocket knife. Let me go give it to Mama. She's right outside in the car." The security guard says, "Not so fast," and opens up his backpack to find both a knife and a pornographic magazine. The school then suspends Johnny for 10 days for bringing a weapon and indecent sexual material to school. Was the search of his backpack a lawful one? Should they have been able to search his backpack? Again, use that two-tiered test. Number 1 for the initial search, number 2 for the continued search. Answer below. And your last scenario here. On the morning of a big math test, Rochelle Forrest goes to the girls' bathroom and sees Tamika Henry putting something in her sweater. She thinks Tamika is hiding some math information and has long suspected that Tamika cheats. In fact, Tamika was just putting on some underarm antiperspirant, but Rochelle rushes to tell the math teacher, Mr. Desmond, of her suspicions, and he calls the principal. They take Tamika to the office, demand she take off her sweater, t-shirt, and bra, all to be examined by Miss Official, the deputy principal. So Miss Official finds nothing and asks Tamika to lift her arms. Finding no hidden answers, Miss Official says, "I'm sorry, Tamika, that Rochelle lets her imagination run wild sometimes. You can get dressed and go take your math test." Tamika thinks this search was unlawful and wants to sue. Was it a reasonable search or unlawful one? So should this been allowed? Was there enough reasonable suspicion to search? Also then respond to, should a school administrator go that far and search the way they did? Answer below. Alright, now you should have a pretty good understanding of Fourth Amendment in schools and your rights.